welcome to this broadcast from Thames Valley Chamber of Commerce along with Blaser Mills. I hesitate to use the words challenging and unprecedented. I think they've been rather overused in the last couple of weeks, but this is clearly a critical time for the businesses and the business community as a whole of all sizes. During the presentation, James Simpson will endeavour to cover the complex area of furlough and answer your questions. So please do make use of the question and answer or chat box to submit questions live and directly to James. Please do refer back to us as the Chamber of Commerce if you need further information. I will give more details of that at the end. So without further ado, please welcome James Simpson from Blaser Mills. James, I'll now hand over to you.
Okay, hopefully everybody can hear me. Could you just go to the next slide, please, Sarah?
I now seem to have a lag.
Yeah, we've got a lag on the system, haven't we? Okay, well, this is first in, one of our seminars in this COVID-19 series to help businesses. I think my colleague, Matt Cross, is going to be covering business finances and access to loans in another seminar. If you could also move on again, Sarah, please, a little bit about Blaser Mills. Blaser Mills is a full-service law firm. We've got an office in High Wycombe, one in Amersham, also Silverstone and Central London. We cover a range of personal and also business legal needs. I can pretty much cover every discipline that you might need. If you can move on again, Sarah, please. A little bit about me. That's a terrible mugshot of me. I've got about 20 years experience. I'm a partner in the law firm, and I specialise in employment and also data protection. And I'm a non-exec director of a local company in the tech sector, in the agricultural tech sector. Again, Sarah, if you can move on, please. So I think we've got a lag on the system, but what we're going to be covering today is the coronavirus job retention scheme. Until 20th of March, not many people in this country had heard the phrase furlough, but it is a phrase which is used elsewhere in the world, particularly America. And I think the government chose to use the phrase to try and differentiate it from the existing layoff provisions which we have in this country, which sort of predate and go back to the industrial days of the 70s. And so there was always a layoff provision, but the layoff terms required express contractual drafting. And also there was a balance built into the system which enabled employees to effectively trigger a redundancy after a period of time. And that would really defeat the objective of what the government was trying to achieve with this retention scheme, which was about protecting jobs and also trying to help businesses with cash flow and overheads. So I think they designed this scheme separately from that. And the way it works is effectively a grant scheme. The details were announced on the 20th of March, and they were sort of rushed out. And at the beginning, some of the details were quite sketchy, so it took a bit of time for further details to come out. They've come out in bits and pieces. There was another further update over the weekend. And I think we pretty much know now what the scheme covers. There are a couple of grey areas still, particularly around holidays. What's not yet known is the claim route and how you're going to recover the money through the HMRC portal, but I'll come on to that in a minute. So broadly, what the scheme aims to do is to provide job protection or security for employees during this pandemic who are affected and who are at risk of redundancy. And allowing businesses to recoup wage costs in relation to those to protect employment. And the wage costs that will be covered is 80% of the wage costs up to an amount of £2,500 per month. I'll go into more detail in a minute. And the government has said the scheme can backdate to the 1st of March, and it's slated to run until the end of May, although obviously could be extended. It applies to employees who've stopped working as a consequence of the pandemic, and that's why it can be backdated. But as I say, it relates to the reasons for this have to be because of the pandemic. Just move on again, Sarah, please. So first question is, who can claim? Well, basically, it's available to all UK businesses and organisations, charities, including recruitment agencies and public authorities can access it. There are a few conditions. Firstly, the business has to have a PAYE payroll scheme in place on or before the 28th of February 2020. And that's quite a key date that you'll see cropping up in other areas. The organisation also has to be enrolled for PAYE online, and if you're not, you can do that. And I think there's a 10-day period to try and register for that. And you must have a UK bank account. Now, in the update over the weekend, the government clarified that it's also available to individuals who employ people. So if you employ a nanny or a gardener and you're operating PAYE in relation to that individual, then you can use the furlough scheme. And as a nod to where things may be going, unfortunately, with the economy, the government's also indicated that the scheme is available to administrators of companies. So companies that have gone into administration, where the administrator is looking to try and salvage the business or sell it, then the scheme is available to the administrator to use to protect the jobs of employees. Move it on again, please, Sarah. So what is a furloughed worker? Well, basically, a furloughed worker, the way it works is an individual is temporarily suspended from work. All their normal terms and conditions apply. But to qualify for the scheme, the rules it suggests that the employee has to be suspended because of the coronavirus pandemic and because either the work has diminished or has ceased, or the employer cannot afford to pay the wages. So it's a question as to whether it will extend to employees who are laid off for other reasons. It would be, I think it would be good for employers to ensure they have some decent evidence to show reasons why staff have been furloughed, and to keep that just in case the revenue want to ask some questions about it. And as I say, it's a temporary cessation of work, so employees keep all their rights, contractual rights, including the unfair dismissal rights. And the furlough period has to be for a minimum of 3 weeks. We had a question overnight about if someone's on furlough but has to be taken back off furlough for an emergency purposes because another staff member's gone sick. The way the furlough system does work is it does seem that you can interchange. So an employee can be on furlough for 3 weeks and then be taken off furlough and another employee put back on. But if they're taken off furlough before the 3 weeks has expired, the scheme won't apply. And just in those circumstances, I think the employee won't be able to recover the wage costs for that specific employee. And to be designated as a furlough worker, it's effectively change in status. And the revenue have indicated that the employer needs to keep something in writing, and they need to keep that for at least 5 years. And the government has made it very clear that employers must comply with both employment law and contractual provisions. So what does that mean? Well, there are 3 particular areas that employers need to be aware of. Firstly is when you're selecting staff for furlough, you need to have objective and reasonable grounds for selecting the employee for furlough, particularly where you're selecting from within a team. If it's an entire team that you're furloughing, it makes it somewhat easier to show why you're doing it. But where you're selecting someone from the team, there can be issues of the employee complaining that they've been unfairly selected, because it can mean, of course, a reduction in salary. So it's good to have some objective reasoning why you're selecting an employee. I don't think you need to have a full sort of redundancy matrix applied to it, but there just needs to be reasoning. And in many cases, it will be because the business needs to cut costs in the short term. And unfortunately, that might mean that some of the higher paid staff are the ones who are furloughed. The second issue is changing status and also changing pay will require technically changes to the terms and conditions of employment. Now, putting someone on furlough or suspending them from work is something which employers generally are entitled to do, but changing pay, particularly down to the 80% or the 2,500 cap if the employer is not going to top up, is quite a significant change. And there can be problems as to how an employee goes around doing that. Now, ideally, the employees will agree to it. If an employee agrees, then there is no problem. But if the employee doesn't agree, then the employer needs to look at how they move onto the new terms and conditions. And one way of doing that is to look into the contract to see whether you've already got an express right to make a variation. Some contracts are drafted with this right, but sometimes they're not. And then there may only be a variation provision, a clause which often is at the end or the tail of an employment contract, which gives the employer the right to make changes to terms and conditions. Now, the courts don't like these variation provisions, particularly in relation to changing significant terms and conditions of employment. Therefore, it can be quite risky to use that type of provision. If you can't get an agreement and you don't have this right to make this variation, then things can become a little bit more difficult, because the textbook way to make a change to terms and conditions is to try and get agreement with the employee, to consult with them. But if you don't get consent, it's then to terminate the existing contract on the notice required under the contract and offering a revised contract when that expires with the changed terms and conditions. Now, clearly in this furlough scheme, that is going to take some time to do and could obviate the benefits of the furlough scheme. Also, where you're looking at more than 20 staff whose contracts might be terminated, it can also engage what's known as the collective consultation obligations. Now, these are statutory protections for consultation, again, going back more to our industrial heritage, but they require employers to consult with staff through appointed reps, sometimes that can be a union, and to provide certain information. And certain minimum periods of time can apply before the first dismissals can be effected. So if there's more than 20 but less than 100 across a 90-day period at a particular establishment, then the time period can be 30 days. If it's more than 100, it's 45 days. And again, having to consult for those periods of time can obviate the need or the benefit of the scheme. The difficulty is that if you don't go through consultation where the collective consultation obligations apply, is that it's a standalone claim. So employees can bring an individual claim for a failure to consult and get compensation of up to 90 days worth of pay. And they don't need any period of employment to do that. Also, if you're going to be dismissing to re-engage under the new contract, then that is a dismissal. And if the employee's got more than 2 years service, then they can potentially bring an unfair dismissal claim if they don't accept the revised terms and conditions. So you need to just be careful about these obligations. The way you potentially can get round it sometimes is by looking at the 20 employee rule and disaggregating that by looking at where the employees are located, because it's 20 per establishment. And an establishment is generally regarded as a sort of an autonomously managed part of the business. Or you can just reduce the threshold below 20. That doesn't mean you don't have to consult, it's just that the collective consultation obligations don't apply. Going to go now to which employees can be furloughed. And again, key date, 28th of February. Basically, any employee who's paid through PAYE, who's on the payroll as at 28th February 2020 can be covered. And that covers full-time employees, part-time, agency workers, including those who are employed via umbrellas, so an intermediary of some form, covers flexible employees, flexible working employees, and zero-hour contracts. The upgrade over the weekend also explained that apprentices on apprenticeship contracts can be covered, and what also can be done for apprentices is that, and we'll see later on, apprentices can continue to train if they're furloughed, but you just need to be careful about the pay, because if they're training, they're entitled to be paid national minimum wage, and if the 80% takes somebody down below national minimum wage, then that might become an issue. You can also furlough employees who are shielding, so they're off work because of potential infection, and it also covers employees with caring responsibilities, so those who are having to look after elderly parents or children. It also applies to those on fixed-term contracts, including where the fixed-term contract expires during the furlough period. The employer and employee can agree to extend and still be covered by the scheme. And then, again, put into the guidance over the weekend, there is this sort of class of non-employees who are also potentially covered by the scheme. That's office holders and LLP members, company directors and LIMB workers. So office holders are typically company secretaries or directors of companies, and provided that they're receiving some of their pay in that position through the payroll, the furlough scheme can apply to them. For company directors, and that includes company directors of sole director companies, theoretically the furlough scheme is available to them as well. However, because under the furlough scheme you're not entitled to work, that can pose some problems. The government has said that company directors can undertake their statutory duties in relation to that directorship or office, but they can't do any work for the business which would go towards raising revenue or providing services to the company. And I know we had a question on that overnight of someone who said, well, I need to do a little bit more than my statutory duties as a company director, because I need to keep the business running and income coming in. Unfortunately, there is a bit of a lacuna in the scheme rules around this, because the scheme as it's presently drafted would not allow that person to access the furlough scheme. They have to stop work and can only carry out statutory duties. And it looks like the self-employed scheme also is not available to that person either if they're working through a company. So I'm afraid I'll have to look at some of the government grants which are available, which my colleague Matt Cross will cover. I also mentioned LIMB workers. LIMB workers are that category of worker that sort of sit between employee and the self-employed. So they're not fully employed and they're not fully B2B, classified as a worker. They're covered as well, provided again that their pay goes through payroll, whether that's through the end company or through an intermediary. Sarah, could you just move on, please? So how does the salary work? I think we've jumped on an extra slide. So wait for the lag to catch up. There we go. So basically, the way the scheme works is, as I said earlier on, it's a reclaim, it's a grant towards wage costs, and it's based on the basic salary, if it's for a fixed salary as at 28th February, and you effectively take 80% of that to a cap of 2,500. In addition, you can claim the employer national insurance on that 80% and the auto enrolment statutory pension contributions for that 80%. So that's more than, so you can claim more than the 2,500. there was some concerns about employees who have variable pay, who rely on guaranteed payments such as bonuses or commissions. The guidance over the weekend has indicated if it's a fixed commission or a fixed bonus or a fixed payment, a variable payment, then that can be included in the calculation. And there are also questions about what happens if, when you apply the 80%, it takes you down below national minimum wage. The government's view on that is if you're furloughed, you're not working, and therefore you're not entitled to national minimum wage, and therefore you can take the wage below national minimum wage with the 80%. But as I said earlier on, if someone is doing some training, so they're doing some work, for want of a better phrase, then that has to be at the minimum wage level to ensure that the minimum wage regulations are met. Where it's for employees whose pay varies, so for example on 0 hours contracts or hourly based contracts, the way you work the calculation is to look at the same period in the previous, same month in the previous year, or you take an average across the last tax year and take the highest of either of those. If they've been employed for less than 12 months, then use the average for the current year. And there were lots of questions around whether other elements were included in the calculation. Unfortunately, discretionary commission and bonuses and other supplements, including tips, will not fall into the calculation. Benefits in kind, and including salary sacrifice benefits, also will not form part of the calculation. But the government has noted that in salary sacrifice schemes, it is possible for people to opt back out of sacrifice for certain life events, and the government is regarding the pandemic as a life event, which would effectively enable someone to opt out of a sacrifice to recover the full unsacrificed pay. The other thing that you can't claim for is the Apprenticeship Levy, which will continue, and also student loans, which will also continue. And note, all the employer is obliged to do to access the scheme is to pay the 80%. They don't have to pay the additional 20% or more, depending on where the cap rises. But of course, it's a choice for employers to pay that additional cap, and some are doing it, and some are also doing it in relation to holiday time. Sorry, if you could just move on, please. So I think there was the slide we've jumped over. Just go back one, please. Thank you. That's it. So what happens if someone's already made redundant pre 20th of March, post 28th of February? Well, the government said that you can include them in the scheme. Effectively, they need to be rehired or re-engaged, and provided they're on the payroll on the 28th of February, they can be included. There was something in the guidance that said that employees already on reduced hours or pay cannot be furloughed. So this suggests that if you've already taken the steps to take people down on reduced hours or reduced pay, the scheme will not apply to you. Slightly grey area on that, because it may well be that the guidance is simply referring to the fact that if they're working, they can't access the furlough scheme. If you have reduced pay and hours and are then going to place them on furlough where they won't be working, the scheme may still be available, but that's something that needs to be clarified with HMRC in further updates. You also cannot claim for employees who are self-isolating or sick because they'll be on statutory sick pay until that expires. And for employees on maternity leave or other forms of parental leave, the guidance again is a little unclear on this, but it seems to suggest that they will continue to receive their statutory entitlements to SMP if placed on furlough, but you can use the scheme, the furlough scheme, to claim for any enhanced contractual pay that is paid. So if you top up SMP by a contractual amount, then it seems that theoretically possible to recover that. The other area where the guidance is a little grey is in relation to holidays and holiday pay. So does holiday continue to accrue? And what happens if an employee decides to take holiday when on furlough? What level of pay are they entitled to? I think because going back to one of the earlier slides, the employment effectively continues as it was. It's just a suspension from work. It would be like any other suspension from work, and therefore holiday would continue to accrue under the working time regs. That's my personal view. In terms of whether an employee, what they're entitled to when they take leave, it's a question whether that's at the 80% or the 100%. Some employers are using this as a way of allowing employees to top up and therefore are paying 100% on holiday pay. I think jury's out in terms of where it fits if you don't top up or don't want to top up as to whether it's at the 80 rate or at the full rate. We'll have to see, but I suspect that it will be at the 100% rate. Sorry, if you just move on, please. So two more slides on. That's the one. So again, we had some questions on this overnight. Can furloughed employees continue to work? Well, basically, when on furlough leave, the rule is that an employee cannot work. They must cease working and must cease working for 3 weeks in order to qualify. As I discussed earlier on, the system does seem to say that you can bring people back from furlough and place others to replace them on furlough. So you can interchange, provided that it's a minimum of 3 weeks. The rules also say that staff can undertake training for the employer, but what they can't do is do any work for the employer that makes money or involves services to the company. They can work for other employers. So if they already had a job with a different employer, then they can continue with that, and they can be furloughed from that role as well. If they didn't have a job but want to get second employment in order to recoup some of the wage loss, then again, they can do that without prejudicing the furlough with their present employer. The only thing to mention there is that because the contract is continuing, if that employee is proposing to do work during the normal working hours, they can be required to get consent under the contract from their employer in order to take up that second job. And of course, an employer may have a view on that, particularly if the employee is looking to work for a competitor or an organisation which is not really in the company's best interest. And the government was quite keen to allow people to be able to volunteer for work as well with organisations, with charity organisations, although they caveated that by saying, please be aware of the social distancing and rules around being out and about. Sorry, could you just move on again, please? So how do you recover the grant? Well, the payment, the 80% or the 2,500 cap is the gross amount. So you still need to apply PAYE to it, but as I've said earlier, you can recoup the employer NI and also the statutory pension contribution. You effectively designate someone as on the furlough scheme through a yet to be created portal, which HMRC is setting up. They say it should be available by the end of April. They don't have any facilities at the moment to be able to do this. That means that I think most employers will have to be paying the wages in the short term and then recouping it by way of a payment in the future. So just bear that in mind for cash flow purposes. And the revenue is suggesting that when you register on the system, that your calculations will be not the 100%, but the 80%, so they know exactly what the claim is. And you'll need to provide them with certain information, which is listed there. So it's basic sort of payroll information. There's a slight typo down there when it says employee bank account. That's employer bank account, because of course they need a bank account in order to pay the money, and it has to be a UK bank account. And sorry, if you go to the next slide, please. And so that covers the scheme rules. I've been watching the Q&A session, so just going to run through some of the questions which have popped up. So Andrew, who asked a question, for high salary employees, will the 2,500 be the net value the employee receives or the gross? That's the gross on which you'll have to apply tax. Then someone's asked, presumably if one pays the 20% balance, there is no issue. I guess that's in relation to the contractual changes. You're right, yeah, if you're going to be paying 100%, there's no change to the pay provisions in the contract, so it's much easier to get to put them on furlough in that situation. Lorna O'Connor, if staff were given a pay rise on the 1st of April, would we need to pay 80% of the higher amount, even though we can only claim 80% of the salary as at 28th February? I think this comes down to, you're right, you can only claim the 80% of the salary as at the 28th of February, but if you're going to furlough somebody, you're going to be effectively, most employers will be looking to change it so you're only paying what you can recoup through the furlough scheme. So it comes back to the point about changing the terms and conditions to a pay level, and you'll be changing it if you only want to limit to the 80% of the furlough allowance to that pre-salary increase amount, because that's the only amount that you can recover. Now, of course, if you want to pay slightly more, you can. You would be topping up, but you wouldn't be able to recover it under the scheme. Chris Jones then says, in terms of the type of work an employee can perform, could employees be asked to develop new service offerings for a business? This would not be billable work at this stage, but R&D. Interesting question. It's a question of really whether it falls into training. And I think it probably sits on the line. I know some employers who are effectively asking employees to develop their skills in new areas to be able to provide new services as and when they come back from furlough, and I think that would fall within training. Developing new service offerings strikes me as being not training, but there's providing a service to the business because the service is developing new product lines or new service lines. So I would tend to think that would be on the wrong side of the line and potentially caught or potentially preclude you from claiming under the scheme. It might be a question that you can put to HMRC when the system goes live. Another question from Lorna O'Connor, part-time staff, how many hours can they work elsewhere? E.g., if they can normally work 20 hours with us and they've been furloughed, can they work elsewhere for the additional hours, and is there a maximum? I think this comes back really to consent and what you're happy to do, because if they're furloughed with you, they're not entitled to do any work under the scheme if you want to make the claim, and it's a matter of what you're happy for them to do for a different employer. It won't affect your claim under the furlough scheme. It's just whether, as I say, whether you're comfortable to allow them to work how many hours with a different employer. Claire Child, hello Claire. Good to hear from you. Can someone be on holiday and furloughed at the same time, or will holiday break the furlough period? Grey area. I think someone can be on holiday on the furlough period. I don't think it breaks the furlough period because they're not working, and therefore I think employees can just categorise a day in the furlough period as holiday, and say there is a question mark as to how much they get paid for that day. It's also theoretically possible for an employer to require staff to take holiday when on furlough. You can give notice to an employee that you require them to take holiday, and under the working time regs, you have to give twice as much notice as the holiday you're asking them to take. So if it's 5 days you want them to take, you need to give 10 days notice. I think we're all hoping for some further updates about holiday and how it will work. Claire, hopefully just keep an eye out for the guidance coming through from the government on that. Caroline Maycock asks us a question about apprentices. If you're furloughed and their wage is already apprenticeship minimum wage, then this 80% will take them under minimum. Does the employer have to top up? I think, as I mentioned earlier on, if they're not working, then the way the government words it is they're not entitled to be paid minimum wage. So therefore you can take them down if they're not doing any training or work. If they are doing some training, then you've got to at least pay the minimum, and you would only be able to recover the 80% of what's been paid. So you would have a cost for that top up. Question from Julia about, is a pregnant worker counted as shielding or self-isolating, and can they be furloughed? I think a pregnant worker, this is, I'm assuming here that somebody who has been sent home as a health and safety concern, and I think going back to the scheme rules, you're effectively, it's about protecting somebody who is at risk of losing their job because of the pandemic. Under the shielding rules, you might be able to just kind of a quick look at the shielding rules. Yeah, the guidance says basically you can claim for furloughed employees who are shielding in line with public health guidance. So I haven't gone into detail on the public health guidance, but if the public health guidance is that you can shield pregnant workers, that would suggest that they can be furloughed. I would suggest you have a quick look at the public health guidance in relation to pregnant workers to see if that falls within that scope. Steve Hanks, if we don't cover the 20%, then we need to change employee T's and C's. Technically, yes, because it's a change to terms and conditions, you're reducing pay. And we discussed that earlier on about the complexities of how you might need to go around that. Hopefully, staff will see it as protecting jobs and will agree to the change. A question about what difference between shielding and self-isolating, and if currently self-isolating, can the person be furloughed if they stop work? Just going to have a look at the guidance on this. The guidance says that if your employee is on sick leave or self-isolating, they'll be able to get statutory sick pay. Shielding is where somebody, as I mentioned earlier on, is being shielded in line with the public health guidance, or need to stay at home with someone who's shielding. I think what you probably need to do is just have a look at the public health guidance on shielding to see the differential between someone who's shielding and someone who's self-isolating and therefore on sick pay. I'll just quickly, shielding is in relation to vulnerable people. So if they're extremely vulnerable, they'll probably fall into the shielding category. If they're not, then they'll be into self-isolating and onto the sick pay provisions. Question from Lorna. If a person's already taken unpaid leave because they can't do their job due to COVID-19, can they now be furloughed and backdated? this is this slightly difficult area of whether someone's already on reduced pay or hours, can they be furloughed? And the guidance suggests they can't. I would suggest that if this person comes back to work and is then furloughed, that I would imagine that I think the scheme then would cover them. So they might want to do that for clarity. Lorna also asked, our payroll is already online, but you're changing to a different provider. HMRC guidance isn't that clear on this, but I would imagine what they're wanting to do is to ensure that everyone's online so that they can have better access to the information. So it strikes me as that wouldn't be an issue. Madia Aslam, how do the provisions work for those whose employment is training in nature, e.g. apprentices, training solicitors? Can they be furloughed and still work as it is training? I think the view on this is that training, there's going to be I think a line between what's providing work or services or pure training. I think it's going to be very fact sensitive, but I think certainly apprentices and trainee solicitors can be furloughed, and certainly what we're doing is we're not allowing trainees to do any client work or work for solicitors, because that is effectively potentially producing revenue for the business, whereas we will be allowing them to do online courses or other courses to support their learning. So I think it's a bit fact sensitive, but I think you need to be careful that they're not doing anything which is actually doing something for the business or producing some revenue. Caroline Maycock, does the employer have to top apprentices up to the apprenticeship or national minimum wage? Well, it will be whatever the national legal minimum wage is for that individual. Sorry, I don't know the ins and outs of the apprenticeship scheme, but if there is a national minimum wage for that apprentice, then it will be that minimum wage. So it's whatever the legal requirement is for pay for someone who is effectively working, but in this context, they're actually training. Andrew Salmon, if we look to do new service development but use a university degree student on his industrial training year, will this change the stance from the earlier question and now be classed as training for the furloughed student? Again, it's quite fact sensitive, and the guidance isn't entirely clear, so I don't think I can give a full answer to that. It's sort of borderline. I think that's something really I would check with HMRC as to where their view lands on that, whether providing work to a student is classed as training. I can see an argument that it is. But I think the way the guidance is drafted, if it's providing services or producing potential revenue for the business, equally it could be regarded as work and therefore not allowed if they're placed on furlough. I think really the scheme is really driving at people not working at all and the training being quite limited. So I would really err on the side of caution in this by not asking people to do significant amounts of work as training, because I think it will disqualify them from the scheme. Graham Northey, are all employees currently working from home as advised by government guidance, and which might be construed as self-isolating, still eligible for furloughing? I think if they're currently working home from, as advised by the government, they're available for the furlough scheme. It's if they are working from home because they are infected or potentially infected that they would be covered by the sick pay scheme. And just picking up some other questions on the chat. So Ron McGuire, closed our office on the 24th of March and advised them verbally of furlough, although we did not make it official until the 1st April by letter. Can we still claim for the last week in March? Also said employee phone number. I think I dealt with that as a typo. It's employer phone number. Basically, Revenue want to see something in writing to confirm the furlough. The key date is when they stopped working, and if they stopped working before the letter confirming the furlough, that's fine, as long as the letter or agreement reflects the fact that they stopped working on the earlier date, and you can support that with evidence. I think there's a question about pregnant workers, and we've dealt with that one. Question from Di Jones: how does furlough affect the ability to make employees redundant in the future while they're still on furlough? It doesn't. Redundancy will be a separate matter. It's one of the reasons why some employers are getting the collective consultation going as part of the placing people onto furlough scheme, because then the 30 or 45 days are being used up, and particularly where employers are contemplating they may need to make redundancies at the end of the furlough scheme. But if you need to make redundancies, then you'll have to go through redundancy consultation, and that's where you will need to have a proper, if you're selecting from pools, have a selection criteria and matrix for selecting the staff that are going to be made redundant. And I don't think you can, or it would be reasonable for an employer to simply to confirm that those on furlough are the ones who are going to be selected. I think if people are selected for furlough from a team and you haven't done an existing matrix or selection, you're going to have to do a proper, thorough selection process before you make someone redundant. Chris Galley: one of the requirements for furlough was that the employer cannot pay wages. What is the burden of proof for this? Nobody really knows. What the HMRC have said, or the government have said, is that they're not really trying to, they are concerned about fraud, but not overly concerned about fraud. The system's been designed in a way to try and eliminate as much fraud as possible. And therefore, I don't think HMRC have either practically got the time or the facility to be able to really drill down into evidence to support what's going on. I think it's good to have the evidence, obviously, but it's going to be a declaration which the employer is going to have to make when they submit the portal that they meet the criteria. Other than that, I think in terms of whether you have got grounds for saying that you can't support the employees because of the business, it's obviously difficult to predict in the future what's going to be happening in the economy. So I think a business can make some fairly broad assumptions as to what their cash flow position is going to be and make decisions based upon that, provided they're reasonable. Question from Jackie Evans: if an employee has two contracts with you, can be furloughed for one contract and not the other? Well, that's an interesting question. Dual employment. I think it depends upon the nature of the dual employment. Not come across this before. I think if it's genuine, well, the scheme rules would, on the face of it, suggest that you can't do any work for the employer because it would prejudice the furlough scheme, even if it relates to a separate employment with the same employer. I think on that, I think you need to be very cautious, and I think that the fact that they're working under a separate contract for you may prejudice the operation of the furlough scheme, because it's not specific to contracts, it's specific to doing work for that employer. Question from Tony. Why would they backdate to March 1st as that lockdown only started on 23rd March? If we bring someone out of furlough for a week and then back for minimum 3, is that allowed? I think, Tony, I think some employers were quick off the mark when they saw things going on and wanted to make some quick changes, and therefore started making redundancies early in March, which is why the government has backdated it to try to protect staff in that category. And if you do bring someone out of furlough for a week and then back, yes, the way the scheme's drafted is it's minimum 3 weeks, and it seems that you can rotate people around furlough, even if it is the same person going back on furlough, provided it's a minimum of 3 weeks that they're on the furlough scheme. And I think quite a lot of questions there. Oh, I've got some more. One final question, I think, from Steve Hanks. Can we make one person redundant straight away, pool of one, or do we need notice consultation period? A couple of fact-sensitive points here will be, firstly, does the employee have more than 2 years service? Because if they have less than 2 years service, they don't have the unfair dismissal right, so it makes it somewhat easier. Question whether at the same time you're making another more staff redundant, taking over the 20 threshold, because if you are, you may be caught by collective consultation and therefore have to go through those rules. If you're not caught by collective consultation and the employee has 2 years of service, then effectively the dismissal has to be fair, and that means going through some form of consultation, and and that means looking at the pools, and if it is genuinely a pool of one, then the consultation can be relatively quick. The guidance is, or the general rule of thumb is, you shouldn't be less than 2 weeks, although you can be less for special circumstances, particularly insolvency circumstances, but you'd struggle to get away with less than a week. So if it's genuinely a pool of one, then you might be able to move relatively quickly to making that person redundant. When assessing the pools, you need to be looking both vertically and horizontally, so people above and below and to the side, and have some objective reasons for why you've arrived at the pool. The tribunal's less concerned at how you've arrived at the pool if you've asked the right questions and done the right assessment, and providing that where you ended up is on the face of it reasonable. But you have to go through the analysis of the pool, the size of the pool, otherwise that can render the dismissal as unfair. I hope that answers the question, and I hope that answers all the other questions. So are you still with us?
Yes, I am still with you, obviously. James, thank you. Thank you so much. Very, very comprehensive answers. And I'm sure that you'd be happy to answer more. Your details are now on the screen if people need them. And of course, please, to all delegates listening in, keep up to date with the latest information on our COVID hub, or get in touch directly with your account manager or your employer's account manager, because as employees of anybody who's a member of the Chamber of Commerce, you are still covered by all our products and services. One of which is a legal helpline, but of course we'll refer to James in the first instance. That's it from me. Thank you so much. Do please stay in touch with your Chamber of Commerce. Thank you for your time. The slides we shared on the Chamber of Commerce website as well. So stay safe, stay well, and stay home where possible. Thank you so much, everybody.
Thank you, Sarah, and thank you everybody for joining.